I'd like to call the meeting to order of the Board of Leavenworth County Commissioners. We'd like to invite everyone to stand for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. For the record, all three commissioners are present. We're going to move the agenda around a little bit, and we're going to start off with talking about the Patriot Highway. Commissioners, you want to make a comment on that?
Yes, I did some investigation. Okay, how's this? I did some investigating yesterday along with staff, and there's several things that we're not allowed to do and can't do. It's against the law. KDOT has been notified, and they are not aware of this program, and they would not approve this program. So I think this is a dead issue myself. I don't think there's any, I don't think the commissioners, myself, I don't know for a fact, but I don't think we're not developing this highway. I got an email this morning and said, I don't know what you're trying to do, but you're not going to put a multi-lane highway through my front yard. You can go to hell.
And I want to apologize on behalf of the board. There's no way we could have responded to all your emails or phone calls or text. I appreciate all of you showing up today and taking time out of your busy schedule. I wish more people get involved in government like this. With that being said, you know, Kansas counties do have broad authority on construction and maintenance of county roads and may enter into interlocal agreements with other entities, government entities, cities, counties, county line roads, stuff like that. We can't really enter into this, so I'll entertain a motion.
Well, I'm going to move that we kill this thing, but but I think we also need to say, first of all, the only entity in the state of Kansas that can have anything to, the only entity in the state of Kansas that can have anything to do with the toll road is the Kansas Turnpike Authority. As far as I know, Bradford has not made contact with them at all.
And I did check on that yesterday, and they don't.
We cannot use our power of eminent domain for a private project. So I move that this matter be permanently tabled.
Voting.
I'll second that motion.
Voting.
Aye.
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 And I'm sure part of your motion would be people don't have to worry about their homes being taken from them. Okay. All right.
Now, I'll say one more thing. This doesn't mean that Bradford, this doesn't mean that John Bradford could not go on his own individual way and apply to the Kansas Turnpike Authority. But I don't think he's going to get any house at all from them. So I did want to say that. But we have no control over that.
Yes.
I was curious to know if it's gone on in any of the other counties that were involved, like Miami County and that, what have they decided on it?
I can answer that.
Okay.
I did talk to the chairman of the board of Miami County, and they have turned it down also. Doug and I went to a Mid-America Regional Council meeting Tuesday, I think it was.
Yes,
Tuesday, and I went to also to a workforce meeting, and I asked in the workforce meeting that there was a Johnson County commissioner in that And I asked him about this Patriot Highway, if he had been approached by John Bradford. He said they had, but he said that's all they could talk about. He said he would not talk about it. And so I don't know if it has not come to a vote or why he wouldn't talk about it, but that's what he told me, and that's the only two references I have.
And I'm sure that on Johnson County's level, they have 7 commissioners, and so 2 or 3 of them can meet.
Right.
And now, our board is a 3-member board. We can't go to each other's office when we get a document like this. We can only talk about it in public meetings. So for the delay of our voting on this is because of that. Yes, sir.
Sir, hi. Thank you for your words. They're very encouraging. If I understand right, you're saying the county commissioner, county government has no authority to get involved in this either way. So is there a way this could get pushed through around you guys
At the state level.
at the state level?
The Kansas Turnpike Authority could, if they had any interest in this, take over the project. But he's not even approached them
Right.
that I know of.
Okay. Thank you very much.
I would just like to thank you all for your research.
Well, I appreciate everybody taking time out of their
Yes.
busy schedules to come today, and I really do appreciate a lot of the emails, but like I said, we had such an influx, there's just no way we could respond to all of them. Yes, ma'am, in the back?
I do want to note that McIntyre Road is the emergency lifeline to us people that live out there in the county. If McIntyre Road is taken away from us, we lose Fire District 1. They have a longer distance to get around to us. EMS is going to have a longer distance. And you may be losing lives on top of us.
Yeah.
And it's not fair to us that we lose our lives, our homes, and everything else.
Well, issue's dead, so
With that, sir, you guys are saying the issue's dead, but I know that, at least from what I understand, and I could be mistaken, so somebody can correct me if I'm wrong, I believe there are future meetings scheduled, at least one in Baser that I'm aware of. Has that been canceled, or who is behind that?
Mr. Bradford has set up meetings.
That's him.
That's
Okay, so-
it's not,
so that's far
it's
as-
not Leavenworth County. Yes, ma'am.
Okay. When you say, I haven't been in 4-H for years, so when you say permanently tabled, are you saying dead?
As far
I'm
as,
saying dead.
Yeah.
as far as this commission is, it's dead.
Well, that's just what I wanted to make
So-
sure with you guys. Thank you.
So, yes, ma'am.
I would like to know, how do we find out about the other resolutions of the other commissions in other counties? How do we know when it's totally not going to happen? Because I really appreciate you guys understanding that, but there's other people behind that. How do we find out?
I'm sure when they discuss it, that you can go to the other counties and ask for Kansas Open Records Act and get any information. But
Chairman, I also think if it should move, which I don't think it will, the Kansas Turnpike Authority would put notices in the newspaper of hearings and events that you could be invited to attend. But those, I don't think they're going to happen.
Could we approach the Kansas Turnpike Authority now with letters or emails just to say our feelings on that? Is that
Molly?
I think they've already been contacted, and my understanding is that they don't have any involvement with the program right
No.
now. They have not been approached or have any involvement.
you do have representatives at state level.
If with that, saying we have representatives, now we got a pretty good constituency here, can we rest assured that you folks will be at Mr. Bradford's meeting then in Baser?
No.
If he tells that, you will not be attending?
I will not.
I understand. Will you be speaking to him regarding this meeting, or do you think?
Yes. Yes. So with that, I'd like to, I'll make a motion. We have a 5-minute recess to let everybody that needs to go, go, and everyone's welcome to stay. I just know a lot of you took times out of your schedule, took off work to be here. Just like to give everybody an opportunity to get back to work.
Thank you.
Can I get a second? Recess. 5 minutes.
Second.
Voting.
Aye.
Aye.
They are.
Until the next battle with these folks arise.
Won't be that hard.
I hope not.
I may go around the table, that's all.
I can do that. See, that's the meeting. It takes engineer to go through this. I can drive my hands without doing it. Just a second.
Curious, I live right on the red, so my house would have been taken crazy. My water guy out there told me that I live on the best water source in the state of Kansas. So they're gonna put that right there. That's what they're planning. That they can have that water. Is that if they have it, can they come and take it? That's my question.
Yeah.
They can't. That's my concern.
Yeah.
That they're just gonna try to steal the water in Kansas. I know it's a weird concept, but that's my thinking.
My thinking too.
All right.
About that, because when Alan told me that this is the best water source.
Well, I think if I was you, I would call Pacer Mayor, find out, or Pacer City Council, and find out if there is a meeting scheduled at Pacer to discuss this.
I'm working that they have this.
I mean, they don't have the authority like we have the authority.
I was reading in our laws that they can't pump water and take it out of the state of Kansas.
Which makes it difficult.
So that's why I was asking you if they can do that. I mean,
If they get KDOT's approval, they can just about do anything. See, what they want is they want us for condemnation rights.
Yeah.
And I pointed that out in the MOU already. And
So there has to be legislation change
but
to get this.
as the attorneys talked to me yesterday about it,
mean,
we don't do that.
Right.
We can't do that.
Right,
It's
you don't
against
have
the
that
law.
authority.
When I said there's things against the law that we can't do, that's one of them I was referencing.
All right.
it just concerns me that you walk with that water and they take it, that whole route looks like it's the water. I don't know.
Well, you're welcome. Yeah, the caucus.
Anyway,
It's on. He may be. So we changed the standard. And so in fact, he wants to do the dust control the last year. Do that, and just regrade, clean things But they're only doing 160. Thank you. Good to see you.
Good to be seen. Rather be seen by two than carried by six.
There you go.
That's a good point.
You want me to stay?
You can take a few with you. You can take that one with Mr. Clapper. That's your job.
I know.
That one lady come up, shook my hand, and thanked me. She was crying. She was in tears.
As soon as Clyde gets get going again.
You could see her lip quivering.
I thought maybe John Bradford would be here today. He's smart enough to know.
I was gonna say, yeah, he
No, he's told me he's coming.
I was just, well, he didn't see the crowd. He's like,
Clyde
I
didn't.
know, like, around these people.
Is Clyde here today?
Yeah, he-
Oh.
Good morning. Sorry. Well, they moved them all forward so that people.
Could stand, yeah.
Good morning.
Okay. We may have to shut the door back here so we can hear, so we don't get the overflow. We'll, we'll go ahead and return to regular session now. I'd like to start with public comment. Anyone from the public wishing to speak, come forward, state your name and address.
Hi, Bob Donaldson. I live at 708 Belgrave Court in Lansing. First of all, I want to applaud the commission for your recent decision. I think it's a wise decision. When I first heard of this, I heard of it by watching your televised meetings in the evening. So I want to thank you for that. Those of us that work, it is hard to keep up with what's going on in the county. And while I was doing that, I know that the cities, at least Lansing where I live, they have their meetings in the evening. And I'd like to know if the commission would consider holding at least some evening meetings so the public that works can show up and participate. Now, I know the city does it because they're volunteers on their council. But I also wonder what the reason is for the county not to at least hold meetings at a more opportune time. Now, we saw a lot of people show up today, but if you look at that group, it looked to me like they were a lot of retired people. But also a lot of people took off work because of the agenda item. And I know not all agenda items are going to have that amount of interest. But have you ever considered, or would you consider holding meetings at a different time? Thank you.
Yes, we've discussed it, and we will probably come up with something on that in the near future. But yeah, I understand, and that was the intent of the YouTube is for people who can't attend our meetings that have jobs, maybe 2 or 3 jobs, so they can pay their taxes. But yeah, we'll be doing that in the future, I'm sure. Anyone else from the public wishing to speak at this time? Then we'll move on to administrative business. Mark, Molly, you have any administrative business?
We did conduct a employee benefit committee meeting this week. Had some really good feedback, making a lot of progress on the code of conduct that we discussed. I believe we were on track to have that back before this board in the time frame that was allowed.
Okay, thank you. Commissioners had a chance to read the minutes.
I've got a little administrative business.
Okay.
I guess the contacts went out for all the contracts that this commission seems to be trying to do away with, and because they're a multi-year contract, these multi-year contracts are not impacting the county financially in any way. The only thing they're doing is protecting the people that have multi-year contracts. So they're trying to, this commission is trying to force these people to give up their multi-year contract. If they don't do so, they're going to file a declaratory judgment over the county system across the street. And this commission then will be in a lawsuit with several of the people that they're trying to do this to, but yet they can give David Van Paris a multi-year contract, but they can't give our attorneys, our HR director, there's quite a few people in the county that are multi-year contracts, but that was just made to protect them so that they could do their job honestly and without retribution. And I just wanted this to be known to the public that this is happening immediately.
Thank you, Commissioner. I just want it to be known to the public that we do not feel it's fair to the taxpayers to have multi-year contracts with public funds.
Well, if you don't feel that it's not fair, then why did you give David Van Paris a multi-year contract?
How many years do you think we gave him?
You gave him a 2-year contract.
2-year contract.
That's a multi-year.
You gave 5-year and 3 years.
Now it's down to 4 years and 2 years. And the 3 years are down to, have they not done their job? Yes, they have done their job very professionally. And there's no complaints. Again, this is not impacting the county at all. It's not impacting the county financially.
Probably.
Their severance packages could impact the county. When you don't have a severance pay, you just run to the end of the contract.
When the terms of that contract, Commissioner, say that if the employee is terminated, they are paid the full amount through the end of the contract period,
And
that is illegal.
And you tell me that David's not that way?
No, it isn't.
Yet we pay his, if somebody fights him on that contract, if I go out and I get somebody to say, I want this contract reversed, we have to pay David's legal fees.
And that's different than the others?
It is different than
I don't
others.
think we have to pay his.
And this board doesn't need to decide this. We'll let a judge decide it, all right?
All right.
Let's move on.
I just wanted
Any other
to-
administrative
I just wanted
business?
to know how we're wasting county money.
By giving multi-year contracts.
And you're given multi-year contracts, so what's the difference?
Yes, sir, Dean.
Dino Road, 232 Oak Ridge, Lansing, Kansas. I think there's one thing that's very important that some people have missed in what happened. When the old board went die-sign, which means everything terminates at that point. You cannot bind one board to another board. Everything is terminated. If you talk about David's, it was in the administration of a new board which would carry till a new board would come on.
But I beg to differ. Number one, Mr. Van Paris was terminated for cause, and
We're not talking
this
about that,
board,
we're talking about when he was hired in by this administration.
yeah, and this
The others
administration,
are terminated, they can go die, sign, and that ends it at that point.
Thank you, Mr. Roque. Any other administrative business? And we'll move on. Have the commissioners had a chance to read the minutes?
I have, your chairman. I see no corrections, and I move approval of the same.
second.
Voting?
Aye.
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 I got some OCBs to sign. Need a motion on that?
I move approval of the OCBs and authorize the chairman to sign and date the same.
Second.
Voting?
Aye.
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 And approval of the agenda for next week.
We're having 2 meetings next week on Tuesday. That's fine, and I move approval of that agenda and schedule.
I'll second it. Voting?
Aye.
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 All right. Planning and zoning.
Good morning, Commissioners. The first case this morning is case number DEV-17-043 and 045, preliminary and final plat for the estates at Parson Ridge. Applicant is Joe Herring with Herring Surveying Company. Applicant is looking to plat a 5-lot subdivision. The subdivision meets Leavenworth County planning and zoning regulation in regards to width-to-depth ratio, minimum lot size, minimum frontage, etc. Beyond that, Public Works is recommending improvements be made by the developer for 179th Street. The Planning Commission voted 5-4 to approve the preliminary and final plat without Public Works recommendation. Besides that, the applicant is here this morning and can answer any questions, as well as myself, regarding this preliminary and final plat.
I don't have any questions on the plat.
I don't either.
No.
But I do have questions on why the Planning and Zoning Commission decided not to make this developer develop 179th. Do you have any reasoning behind that, any facts? I thought that was part of a...
That's actually part of the requirement by Public Works, but the Planning Commission thought that they were more siding with the applicant on it. They had, we can check with the applicant for their reasons. So the applicant may be able to answer that question.
Okay.
Would the applicant wish to speak at this time?
Joe Herring, Herring Surveying, 315 North 5th Street. Basically what happened was we worked hand in hand with Public Works and Planning and Zoning on this. The client had purchased 3 buildable tracts, 160 acres combined with 3 separate deeds. We adjusted them down to 3 different size tracts and then came in and platted. So we started with 3 buildable tracts, we end up with 6 buildable tracts. So through the process, we only increased the number of buildable lots by 3 and not triggering the road improvement under that theory. I believe that Planning Commission approved it 5-4 without road improvements because the other alternative was to bring in 2 separate plats, a 3-lot subdivision and a 2-lot subdivision, and going to end up with the same thing, and that would not trigger road improvement.
So you're going to end up with 6 lots, so that's just another way. I think we had the same problem with, is Dave Luchin in here?
He's here.
Yeah, I'm here. Okay. Didn't we have this same problem once before with Mr.
Not exactly the same,
But it's similar.
It is
I
similar,
mean,
but-
what they're doing, they're bringing up 3, and then they're bringing up 3 later, and that makes it 6 lots, and that should be development of the road. Am I right or not?
But you're saying you had 2 separate tracts of ground, large tracts of ground, and you put them together, or 3?
We had 3 separate tracks. We had 3 buildable tracks already.
But now you have 6 lots.
Now we have 6 buildable tracks.
Right.
So we increased
So you
them.
need to develop the 179th Street.
No, we
You could have kept the tracts separate, correct?
We could have brought this in as 2 separate plats, spread the lots up, flag shaped some lots, had been done. Planning and zoning didn't like that. We worked with them. We met the final meeting with Public Works and Planning and Zoning. We said we could bring it in as 2, bring it as 1. We were told now's the time to do it. We did it. They're asking for a half-mile of road. Planning Commission approved it 5 to 4 without road improvements, and that's what we're asking for, approval by this board to support what Planning Commission said. You have a 4-lot subdivision directly north of it, didn't have to improve the road. It's just, we're only increasing it by 3 buildable lots. If you increase the 4th buildable lot, makes it, triggers the recommendation, still not a regulation, the recommendation to improve that road. That is still not a regulation. So
It's just another way of superseding.
It is not. We followed the regulations going through the process. The actual regulations, we followed. The rule of thumb, if you increase over 3 buildable tracts, they recommend you improve the road. We increased 3 buildable tracts. Over 3 buildable tracts, Bob, over 3. We increased 3. That 4th buildable tract triggers the road. We did not go to that 4th buildable tract.
But you got 6 buildable tracts.
We already had 3. This wasn't a solid one piece. This was 3 buildable tracts. He could have went out there and built, have 3 homes out there when he bought it.
David, do you have anything to add to this?
You sure that's okay?
Yeah, all right. It's never been looked at how many buildable tracts you start with. It's always been looked at how many lots you end up with.
That's right.
We've given exceptions if there was an existing house on a tract. Like he recently did one that had 4 lots, but it had an existing house. So
Right.
we didn't make that recommendation at that time. That was one he just did, I think, last month. We've never looked at, well, you're starting with 3 parcels. That's never how it's been looked at. It's never been looked at in that manner.
So if he has 10 buildable tracts,
Correct. It's never been, we've never looked at it like that. The exception's been if you have an existing house on the tract, but never just that it's a separate tract, so.
Okay, one of these did have existing structures on it, but this same case, Dave and I went through this in Planning Commission, same discussion. Then we said, okay, well, we can come back and take the north parcel, which is 15 acres, and plat that into 3. We could come back in with a second plat on the second parcel, which is 10 acres, and plat that into 2. We're gonna end up with the same situation. It's not gonna trigger road improvement. And we're gonna end up with 5 lots just in 2 separate plats. And the Planning Commission said, why go through that? 5 to 4, don't improve the road. There's enough reasoning behind it, and we're asking for approval according to the Planning Commission. If the board would rather see this come in as 2 plats so it doesn't stir up everything else, I ask that it get put on the next Planning Commission meeting. Both plats are coming through, and then we'll be on the next Board of County Commission meeting. But it's actually a waste of effort, in my opinion, when we've documented how we ended up where we are.
Okay.
Thank you.
I think this is pretty much the same, similar situation we just discussed with Mr. Brewer just
Right.
Yes.
a month
Exactly.
ago. And the concern was that he was going to do exactly what Mr. Herring is proposing, which
Right.
is do 3 and come back later and do 2.
Exactly.
And so at that time, what they said is approve it as the 3, but if you come back and do 1 more, that's going to trigger, and I think that's what the board at that time discussed. So I just wanted to make sure you remembered that we just had that.
I was gonna say,
discussion.
we
we just did that.
right, a little different circumstances. He didn't put 3 tracks together. Is that what you're saying? You put 3 large tracks together, or?
In theory,
Dan Lynch at 19170 219th Street, 751 219th Street. Hey, this is part of the reason why I come up here today, is because I feel like this board, not necessarily the board, but the planning department, is stymieing the type of growth that we need to do at this time. People are trying to bring plats in, and they're trying to get, so we can get building permits, trying to get tax dollars into the county, and we're not able to get these plats through. In this particular case, Bob, there were 3 existing tracts that were already there. And never is a long time. I don't believe that they have never done this before. I gotta believe that they have. And if I was to bring, I'm gonna go back to my plat that I just did on the Cord property. If I was to try to bring that before this board today, I would never get it through. It'd never be done. You guys are taking a golden opportunity to create growth in this county, and you're squandering it because you're not approving these plats. Now hold on, let me finish here, because we're gonna go back. You brought the Brewer track up, so we're gonna bring it back up.
Yeah.
Okay, let's talk about the Brewer track, because according to your guys' guidelines, that's not an arterial road, okay? So it's already been approved to chip and seal, okay? I disagree. And so, anyway, so that road's there. Those 3 tracks that they were wanting to plat additional tracks, those could be sold tomorrow. That'd be $5,000 each for every one of those tracks that would come into the county. 2 road accesses or 1 off of Evans Road. Take another one off of 174th. No harm is done to anyone other than you're adding tax dollars to your county. This particular thing with Garrett he's brought this plat forward. There's actually 2 houses, old houses, that were on this property. So 2 of those actually existed out there. If you want to take it that direction, this plat should be approved. This shouldn't even be discussed. It shouldn't be an issue with getting it through there, because we're trying to create tax dollars for the county. And I feel like you guys are fighting the problem. People's houses burned down, and you don't want to issue building permits because their house burned down, because it's a non-conforming tract. It's an illegal tract. What the heck? I mean, put yourself in their shoes. If you were to be that person, that house burnt down, and you say all of a sudden, we're not going to issue you a building permit, you're going to get all kinds of sideways. In fact, I mean, I can't believe somebody hasn't brought a lawsuit against this county. This is ridiculous that we're having these types of problems.
And we're going to deal with this today on discussion on buildable tracks later on, as soon as we get through this.
I'll be back.
All right, thank you. Commissioners, you have any thoughts?
Well, if he's saying that we're not taking advantage of tax money coming into the county, well, if we don't make the developer develop the road out in front, who's going to develop that? Tax dollars.
Yeah, but Mr.
Am I
Herring,
right?
Which you have a road impact fee, which you can use to improve that road.
Right.
And if that's the problem,
But is that enough money to do? Is that enough money to do that? That's right. $1 million. What is it? $1 million a mile? Sarah, do you know? Roughly $1 million a mile.
$500,000.
Just get you a seat and sit up here.
You guys receive phone calls, you receive emails, you have people come in here complaining about the dust. To hit on what
That's
you're
right,
saying,
all the time.
development needs to pay for the impact that they are causing, not the county at large.
That's
paying for
right.
that impact.
I agree.
So the RIF being referred to, that's paid on the building permit, so that's usually the home builder, not usually the developer that's paying. So, just following up on your point.
Okay. But at the same time, Mr. Herring could go back, replat, do 3 lots on one, come back, do 3 lots on another, and we're going to end up with the same result.
That's right, and the difference from Brewers.
It's just a way of getting around the
it's not getting
policy.
around
It
it.
is.
It's 2 separate parcels. Brewers was on 1 parcel. We're platting 2 separate parcels. We just tried to streamline it and get it together, is all. And Dave Lujan, in the meeting of Planning Commission, and I hate to speak for Dave, but he said if we would have did that and came back in as 2 separate tracks, he would not have recommended road improvement. So, it's not getting around it, we're just trying to streamline it, is all we did. And the Planning Commission agreed with us 5-4, the way we did it and the way we're doing it is the agreeable way. We're asking for that motion, approve what the Planning Commission did. Thank you.
In the future, Mark, is there any chance of getting together a committee or a group of people and we come up with some policies that are
This is
written in stone?
I think that I think Mr. Herring actually has a very good point in the fact that it is he could have done this two separate entities and got it accomplished. It's a problem that we've been discussing for a while. I shouldn't say it's a problem. It's a challenge that we've been discussing. We've actually been working with the Public Works Department and the legal counsel trying to establish exactly what you're saying, which is how do we address this on a lot by lot situation instead of a 2-lot, 3-lot, 5-lot deal. I think we're probably real close to having that addressed. And exactly what Mr. Herring brought it up, and I believe Mr. Lynch said it, is the RIF fees should cover this. If that's what the intent is, then the RIF fees should cover it. I think we're trying to address something. We should have a policy, I would hope, pretty quick that we can maybe bring in for consideration for the board. So it is. It is
Yeah, I
something we're trying
understand the
to
RIF, but like I said, our building permits are pretty high now anyways.
And the RIF, there's another fee that we're talking about, which rather than try to spell it all out right here, I'd like to make sure that we get it fully developed and bring it in front of the board. That doesn't help Mr. Herring today, and I understand
Well,
that.
until we get it, I'd say we're gonna have to approve this and move forward until we get some policies in place.
I understand that.
Any
Is
thoughts?
that a motion?
Yes.
Second.
Voting.
Aye.
Aye.
Nay.
Thank you.
Okay, next case is case number DEB-17-008, Zigzag Run. The applicant is Christine Magner. She's requesting a renewal of a special use permit for a horse boarding business near 179th and Eisenhower. The business is located on a 10-acre parcel. She's been running it for the past 15 years. She offers riding lessons to adults and children, generally one a day. They can board up to 9 horses and are currently at capacity. She's not looking to grow any farther. I conducted a site visit in March. The applicant has submitted an updated safety plan, and Planning and Zoning has yet to receive any complaints regarding this parcel. The Planning Commission voted 9-0 to recommend approval of case number DEB-17-008, subject to 11 conditions. A public hearing is required and a resolution for this case. The applicant is here and can answer any questions.
Just go into a portion of public hearing. Anyone here wishing to speak for this?
I'm Christine Magner, Zigzag Run Farm. The only thing I'm asking for is the special permit, special use permit to be for 10 years instead of 5.
Anyone wishing to speak against this? Then we'll close this portion of public hearing. Entertain a motion on approving this?
Motion to approve.
For 10 years?
For the 10 years.
For the 10 years?
Second.
Voting?
Aye.
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 We need to approve a resolution.
There's a
Resolution
resolution,
number 30.
but there'll be one change, the number of years.
Yeah.
We have to change it to 10 years.
Okay.
I move approval.
Second. Voting?
Aye.
Aye. Okay, next.
Good morning, Mr. Chairman and Commissioners. This is case number DEB-17-015, special use permit for Adventure KC Zipline. This is a request to renew a special use permit for the Adventure KC Zipline. The zipline is down in the south part of the county along the Kansas River. It's near the cold storage, to give you an idea of where it's located. They have been in operation since 2013 with the zipline. They're before you today to continue using the zip line. Again, that part of it was approved, but they want to add events such as mud runs and fun hikes, that sort of thing, obstacle courses, challenges. They're wanting to add that to their special use permit. Like I said, that's the reason that they're here today. The hours of operation are primarily from 8 a.m. until 11 p.m., with most events taking place between dawn and dusk. They expect about 10,000 guests per year, but this is zoned as I3, so heavy industrial. There's not a lot of housing around there. So we're not concerned about the number of visitors that they will have. They've had no complaints, no issues for the last 4 years that they've been in operation. The Planning Commission voted 9-0 to recommend approval of this. There is a resolution required and a public hearing required, excuse me. The applicant is here and will answer any questions that you may have.
All right, we'll open up the portion of the public hearing. Anyone wishing to speak for this special use permit? Seeing none. Anyone wishing to speak against it? Seeing none, we'll close that portion of public hearing.
Motion to approve.
Second.
Voting?
Aye.
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 Thank you.
Thank you.
We need a resolution.
Resolution number 31.
I move approval.
Second. Voting?
Aye.
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 Commissioners, the next case is case number DEV-17-031, a special use permit application for daycare facilities with Nye Daycare. The applicant is Joan Nye. She's requesting this SUP for an in-home daycare business located near 127th and McIntyre. Mrs. Nye has been running her daycare business for 19 years. It was brought to her attention that she needed to apply for a special use permit and has since done so. The business is licensed by the Kansas Department of Health and Environment and the Leavenworth County Health Department. She's authorized to care for up to 10 children according to KDH regulations. However, Mrs. Nye primarily provides care for 3. Business operates year-round. Children are dropped off approximately around 7 a.m. and picked up by 5 p.m. She has provided the Planning and Zoning Department with a very detailed emergency plan and a copy of her certificate of liability insurance. The Planning Commission voted 9-0 to approve case number DEV-17-031, subject to 11 conditions. A public hearing is required and resolution. The applicant is here and can answer any questions that you may have.
We'll open this portion of public hearing. Anyone wishing to speak for this special use permit? Yes, sir.
Ladies and gentlemen, I am Dan Butler. I reside at 12569 McIntyre, which is immediately adjacent to Bob and Joe Nye. I have been their neighbor, next door neighbor, since they bought the property and built their home there. During the tenure of their child care service, not one time has it proved to be an irritant, and in fact, it's almost unnoticeable. If you do a quick head count at the back of the room, you can see the number of kids that Joan is caring for. It is a non-issue as far as the neighborhood is concerned. Occasionally, you might hear a child laughing in the backyard if you're out doing some work, and I have never found that to be.
That'd be a plus.
That's a plus. That's a plus. So, earlier I came in opposition to another kind of business that was, but in this case, this is just a non-issue for the neighborhood.
All right, thank you, Mr. Butler. Anyone in opposition to this special use permit? Seeing none, we'll close this portion of public hearing.
I move approval of the special use permit.
Second.
Voting?
Aye.
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 And then we have a resolution.
Resolution 31 or 32 for approval.
Second. Voting?
Aye.
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 Commissioners, this is case number DEV-17-046, which is a change to Article 19 of the Planning and Zoning Regulations, the table of uses. This is to allow us to add custom cabinetry to the table of uses. Currently, that's not a use that is within our table of uses. We have had some requests for cabinetry shops in a business zoning district, but we also have a number of people out in the unincorporated part of the county in rural residential zoning who operate cabinetry types of shops and such. And currently, we don't have that use in our articles in our zoning regulations. And so this is an opportunity for us to add that. That's all that you see before you today. It would allow custom cabinetry with a special use permit in the rural zoning. Structures that are less than 7,500 square feet would be allowed with a special use permit in B1 and B2 and outright allowed in B3 through I3. And structures greater than 7,500 square feet would be allowed outright in B3 through I3 zoning. The Planning Commission voted 9-0 to recommend approval of this case. A public hearing is required, as is a resolution. Planning and zoning is actually the applicant, so there is no applicant here. We'll answer any questions that you may have.
I guess we'll open that portion of public hearing. Commissioners have any questions?
No.
Then
Well, I do. Don't
Yes,
we
sir.
have one or two operators that are doing cabinetry work in the county now?
Yes.
What do they operate under?
They typically operate under a small limited business, which means it's just themselves. They don't have any employees. They live on the site. So that's how we've been able to put those through before. But this would open it up and give people some more options, maybe if they needed a couple of employees or something like that. So it just would broaden our ability to allow people to do this.
and regulated. And regulated.
Right, that's what I looked at.
Through a special use permit, which
Right.
they already have to go through a special
Right.
use permit as it is.
Motion to approve.
Well, we'll turn to regular session
Oh.
and get public hearing portions finished, so
Yeah.
we'll entertain a motion to approve.
Motion to approve.
Second.
Voting.
Aye.
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 And then a resolution number.
33. Resolution number 33 for approval.
Second.
Voting.
Aye.
Aye.
Morning, Commissioners. The next item is a complaint that we received regarding a special use permit. It's located at 24619 163rd Street. And our code enforcement officer, she actually went out there like 7 to 8 times over the last couple of months. And we have found only one violation, which is they are disturbing the ground in their backyard. And we reported that to the state, so the state is taking care of it. Other than that, we haven't found any violations.
So really nothing for us to do.
Correct. There is, at this time, there's nothing for us to do.
Commissioner Graber, I believe it's in your district.
Jeff, I want to phrase this very carefully. There's no getting around it that the holder of the special use permit appears to go out of his way to see what he can do to disturb the neighbor. Now, I think that's a fact. What do we do about that?
I don't think we can do anything about that, but all we can do is we have a special use permit and we have some conditions that were approved by the commission. So that's all we can, enforce. Other than that, I mean, they complain about signs being on the fence, and that's a personal choice. I mean, anybody can have a sign. Yeah.
But, Jeff, we grant these special use permits. We tell the party what they can do, what they shouldn't do, but then they go out of their way to antagonize the party that owns the property next door. It just isn't right.
I believe that's a law enforcement issue, so I believe they've contacted the sheriff a couple of times.
I know they have, and that doesn't seem to get them anywhere.
That's true.
Guess the next option is district court. Is that Molly?
Yes, I don't doubt, I'm not denying, there is some animosity between the two of them, there definitely is.
But the holder of the permit goes out of his way to add fuel to that fire.
I think for the most part, a lot of it has to do with disagreements amongst neighbors. I think planning and zoning, to the best of their ability, investigated things that had to do with the special use permit and went out several times. And again, they found one violation which
was addressed by the state. It's not within our, I guess, authority to do anything about, but once staff was aware of it, they did report it to the proper authorities. If there were violations of the special use permit, then court wouldn't be the only option. It would come forward to you to make a determination about what to do about the special use permit. But in this particular case, without findings of violations, I would say probably district court is the option between the neighbors.
I don't know if this is legal to do. Is there any chance that legal staff could send the gentleman that Clyde's talking about a letter asking him to be more respectful of his neighbor, that this has become a nuisance with the county, and just, not a threatening letter, but a courtesy letter.
I think you insert the county into what is a civil matter. And that anytime you have two neighbors then that are in a complaint situation against each other, are you going to issue a letter? And by issuing a letter to only one side, you appear to be taking a stance and taking a side. So you have a disagreement between neighbors.
I think the one gentleman, just like Clyde states, if he would be a little more respectful, I think this thing might calm down, but he seems to fuel the fire.
And I think it would be nice if you would hope that if someone was running a business out of their home, that they would be courteous to their neighbors and intend to get along with them and not be obtrusive to their neighbors. That would be the hope. I think that's normally good business to do that as well. However, I don't know, being a bad neighbor isn't necessarily something that the county can regulate on.
Like I said, if there's been no violations, there's really nothing this board can do. Our hands are tied. We're not a mediation board, so it's kind of outside of our, the district court is the only thing I could recommend for them.
We brought it forward as a request, and just wanted to let the board know that staff is aware of it. They've done as much as they possibly can. And
if there was something we could do, we would do it.
Absolutely.
And I commend Melissa. She's gone out there, Lord knows how many times. And it's quite obvious there are certain things done to put fuel on the fire. But I don't know what we do about it.
You could have approved the highway earlier, and that would have took care of it.
Thank you, Chairman.
But like I said, if there's no violations, I don't think there's anything this board can do. Am I right, Mr. Matthews? As a planning board member?
Right there at the chief, but I would agree. We're powerless to do it.
That's correct.
He's not violating that.
Okay, we've had our second opinion, so.
Okay, thank you.
All right, and like I said, I wanted to bring up about these letters that, so I was wanting to discuss that today. What we have is previous planning directors have issued letters to people saying their tracts of ground are buildable, and planning and zoning doesn't have any knowledge of it. And when these people come forward to get a building permit, we're finding that these lots are not they're not compliant to today's standards. And we wanted some discussion on how this board will deal with this in the future. So anybody wishing to speak on that would come forward and state their name and address.
My name's Dave Teal. My address is 27192 227th Street, Easton, Kansas. And I'm a realtor with Riley & Sons here in Leavenworth, and been a realtor for 30 years. And I brought this to the attention of Doug, and I also mentioned it to Bob in passing too. And it's other situations like this that have happened through the years also, but this particular one Doug's mentioned is a case where a gentleman got a building permit on a property that I guess I would have thought maybe shouldn't have issued a permit, but then when you see what was given, it was basically grandfathered in, and the planning and zoning director at the time was Mr. Zollner, who was fairly rigid and didn't let things go through, and he had a paper trail of deeds and everything else with this building permit, and so I guess the bottom line is I feel like once that's issued, whether it was right, wrong, or not, or whatever, it was issued by a county employee, it should be honored for anybody down the road. This individual bought this tract about 12 years ago and went to the trouble to get a building permit and got an address on this lot, which means he did get a building permit, other than it's not 000. It's got a numbered address, 15809 Fairmount Road. So therefore, he was approved to build his house, and the reason he didn't build is the bids came in too high, and he chose not to build at that time. And now he wants to sell this lot, and actually he couldn't find the letter, and so I asked planning and zoning, a gentleman who's not with you guys anymore. He said there wasn't a letter in place, and then I came back later on this year, and I think Crystal found the letter in the file, so there was a letter in the file that stated it should be buildable. But on the other hand, they said they wouldn't give a building permit now, so is how I understood it. And I guess my whole thought is I don't understand why people get these if they're not going to be honored. I mean, whether they should have been given at the time, that's not the point that should be argued. I think the county should honor these, and this gentleman was going to hire an attorney to fight this, and I said, well, let me see if we can see what we can do and to get this honored. And I don't think it just shouldn't be in this case. I think it should be on other lots where there are building permits. If they were given out by a county employee, maybe they shouldn't have been done, but the fact that they've been given, they should be honored by the current administration, and we shouldn't be wasting your time and everybody else's time on trying to deal with this matter. And the same would go through for a house that's burnt down, and somebody maybe did something down the road that created a non-conforming use property, which you see happened all the time. And I'd say in dealing with a lot of these issues through the years, most of these things are innocent. The people that did them didn't know what they were doing. Probably a professional could have or couldn't have known what they were doing. But the fact is, their house exists and you guys are collecting taxes on it and you're not turning down the taxes. And most people don't even know they're non-conforming use properties until they go get a building permit for a barn or shed or something like that, and then they're told they can't do that. So, I mean, I guess I'm asking you to give the planning and zoning people some latitude to serve the people where these things are at. And I've even had people where I've sold a lot and had a building permit in a lot, and the buyers go in to get a building permit and they say they can't get one, and not necessarily this group of people, but previous people and then you have to fight them and prove this and prove that. And I mean, you just shouldn't have to go through this when people are, lots are correctly platted, or whether correctly, but they were approved by people in the county organizations. I guess I'm just asking, and we've had other situations through the years, and I can name numerous examples where, it takes a year fighting with this, that, and go through the BZA or this, that, and whatever, where the neighbors can get up because they don't like this person and gripe about their dog and fight this and fight that, or whatever, which has nothing to do with the situation, and sometimes they're approved and sometimes they're not. But I don't think these people should have to go through this, on most of these situations. So I understand the BZA has a purpose, and there's a lot of situations where they could be approved, but when prior people have gone through this to get something approved and they have a letter, I think they should be honored, I guess is the bottom line. Well, I thank you for looking at this. Any questions?
Thank you. No, like I said, I think the board had one about a year ago, maybe longer. I wasn't on the board then.
Well, yeah, I mean, I remember one too, and I've been involved in others where there was a bank foreclosure where somebody deeded something off, and we were dealing with that for 2 years, and where nobody had the correct deed. I mean, some of them it's impossible to straighten the situation out when you create a non-conforming use property because the people have moved or sold and there's new people involved, and you can't force people to correct the situation. So they're very difficult to solve, and what's the option, to tear down the house, or you know, I mean, you know, it's kind of like you kind of got to have a little common sense and, you know, leave them go. I mean, the house has been there for sometimes many years, and it hasn't created a problem. The only time it came up is if somebody comes in and gets a building permit to build a shed or a barn, or the house burns down, and that type of thing. And it could have changed hands 2 or 3 times in the process, and there's nothing that comes up in the process, title commitment, or that shows it's a non-conforming use property. I mean, because title work doesn't necessarily show that. They don't deal with those issues as long as, you know, or it certainly doesn't show up unless somebody points it out.
What year did the county become zoned? Commissioner Roque, or former Commissioner? 1972.
And I know a lot of these laws were in place in the 90s.
Regulations from
Yeah.
I know John Zollner was a planning and zoning director when we had these huge meetings over at the courthouse, where people were, you know, fighting against, he was trying to propose all these changes to the, you know, to the planning and zoning regulations, many of which we have today, and things were grandfathered in, you know, things that were done prior to that were grandfathered in.
Right,
and that's
right.
what a lot of these things are about.
And that's what I was, you know, when this county became zoned, I mean, there was a lot of properties out there that were, today's standards, they're not in compliant. I mean,
well, I mean, I've
And
been doing this
I
30
think they
years.
should be grandfathered in. You know, they were prior to that, and then you also had a lot of properties prior to platting, I believe. What year did we go to the platting process?
Same, whenever we have zoning regulations, you have to.
Well, I think they had a lot of lots that were out there that they granted amnesty on prior to '96.
In 1980s is when we required that, and required the tract size, because if you remember, parallel at 166, Mr. Pine started tracking all those 1-acre tracts off, and all the lateral fields ran into the county road. And that's when we put the rules and regulations on it, that you can no longer deed off 1 acre, 1 acre, 1 acre, 1 acre.
Right, but anybody that were holding deeds, did not the county grant amnesty on them?
That was in 1998.
98?
But the amnesty rule stated that they had to meet the regulations at that time.
Right.
Commissioners, the issue is now there. Mr. Teal is right. When these letters were written, I mean, it was a long time ago, they actually did not meet the regulations at that time. So if they had met the regulations at that time, then we would have issued the building permit. There's no problem with that. But for some reason, the letters were written incorrectly. So the issue is not that. The issue is that, you know, they can take the letter to the bank. I don't think they'll recognize that. But the way to deal with this is to go through the process and get it done correctly. Is to, if they need to get a variance, you know, that's a permanent solution. Once they get the variance, you know, they don't have to come to the board anymore. It's all done. But if the letter is like dealt with every day, I mean, the next commission will have to hear the same thing again. I mean, it's a temporary solution.
One thing I'd like to just, you know, building permits expire. And the reason they expire is because building guidelines change. Plats expire if you don't take action on them. And the reason they expire is because guidelines change. A letter that was written by the planning and zoning director 10 years ago would expire as well, and that the guidelines have changed. We don't know what the reason for the letter was. We don't know what existed at that time, as far as maybe there was some kind of an accommodation that was available, but we don't know. And the guidelines have changed. I mean, if that same letter is brought in 100 years from now, do you think it holds any validity when things have changed? So I think you just, I think you have an application of something that, yes, somebody wrote a letter, and at the time, if they would have came in and got a building permit, they would have got one. And they did. They actually used that letter to get a building permit. They just didn't build it.
Well,
so 10 years later, the validity of that letter comes into question because things have changed. The same reason a plat expires, the same reason building permits expire, because guidelines change.
And I believe the town of Fairmount, the
Right.
subdivision north of
Right.
there, was an old plat in the 1800s.
Yeah, we actually rezoned the whole area to 1 acre lot, so they
Yeah.
are compliant.
So that was over
But
100
the
years
fact,
ago.
you know, somebody goes to trouble, there's no expiration date on the building permit that I remember seeing. So, I mean, when you get a letter from planning and zoning saying it's a buildable lot, and why do they grandfather stuff in then if you know, if something was approved prior to that? Then half of the houses in Leavenworth County were non-built, or, you know, there's a good chunk of them that aren't approvable lots because the rules have changed and everything else. So if you want to get technical, you could say there's gobs of places that have no frontage, or you couldn't build, or you know, if it burns down, you shouldn't be able to rebuild them because they're not correctly done. So I mean, when the rules change, which that's why things are grandfathered in, and you can't market stuff and tell people you're buying stuff. Well, you're buying it today, but if you don't build right away, this might not be buildable. I mean, I don't think that's, you know, if you don't want people to come to the county, you just need to put a billboard outside where you enter the county and say, this place is hard to get building permits, so you better keep driving and go someplace else. But I mean, I'm not against planning and zoning and all this stuff, but when things are approved, they should be honored, and people buy these things. I mean, this guy bought this lot saying it was a buildable lot. He didn't know he had to do something or sell it or build within a certain period of time that it would expire, like anybody on a building lot. And I realize rules changed. I mean, a platted subdivision, once it's platted, I mean, there's a platted subdivision where some you know, you can find a lot in town where somebody hasn't built on it, that it's been platted for 20 years, and maybe it wouldn't be platted today, but I think you could you could build a house on it.
Well, I think the one case that kind of brought this to light is a lady that bought a lot. There was a letter from a former head of the planning and zoning department saying, this is a buildable lot. So she buys the lot. She can't depend on that letter? I think she should be.
Why do you? Absolutely.
It was buildable at the time, but that doesn't mean that it should be buildable
But if
forever.
she,
The regulation.
but
Yes, it
Molly,
should
if
be.
she changed her position and gave dollars to buy that lot based on that letter that it was a buildable lot, I'd love to defend it in court.
Yeah, I'd like to.
I wouldn't.
I thought it was buildable. If it's buildable at the time and then the regulations change, the regulations allow for it. They allow for it to be grandfathered in.
At that time, it wasn't buildable, that's the issue.
Apparently it was.
But she didn't know that. She depended on the letter from the head of the planning and zoning department that's signed by him and dated.
With no expiration date.
Yeah.
And the purpose of this whole deal is to allow them, I mean, I don't think it's going to ruin the county or anything, these few that exist, but the exercise that people have to go through to keep them on. And generally, it's the people that made the mistakes aren't here anymore or don't own them. And you get people that are innocent that bought them, you know, because it didn't show up in the paperwork. I mean, people that market these properties, most of them wouldn't recognize a non-conforming use property, you know, because they don't understand the rules. I mean, there's very few people that understand, you know, that it could be a non-conforming just be on concurrent conditions. So you know, and the general public certainly doesn't. And there's nothing in the trail of buying it that it would come to light. And so all we're asking here is to honor these, you know, and perhaps, you know, which would filter down to the people when their house burns down, that they don't have to go through major hassles. If their lot, or if their house was created non-conforming 15 years ago and it changed hands 3 times and they didn't know about it and their house happened to burn down and then they're expected to go through all this just to rebuild their house. I mean, I don't think that's right.
Jeff, I got a couple questions for you. Number one, do you write any of these letters saying these are conforming lots?
No, sir. What we have is a process. We, when people call in to ask if this parcel is buildable, what we do is we research the parcel to make sure that it meets all the regulations. And then as a department, we send a letter saying you're entitled to a building permit on this parcel. So we do all the research, make sure it meets all the regulations, and then we write the letter. We don't write letters without checking into anything.
On Dave's lot that he's talking about, what is not buildable on this lot?
I believe it's a landlocked parcel. There is no frontage on the property. And even,
Well, if
you know,
there's no frontage, how are they going to get into the lot?
correct, that's the issue, that the previous letter said it's buildable, but it's not because there is no frontage. And when the regulation started, there was minimum frontage, even like 30 feet was the
So
requirement.
how are they going to get?
It was a deeded easement that there was a paper trail of deeds that Mr. Zollner had on this building or on this letter that stated it went back, 40 years ago. And so it was based on Mr. Zollner, who was, fairly hard to get things through. He issued the letter, and I know it wouldn't be done today, but it was done back then, or I guess it wouldn't be done if it was grandfathered in based on his theory. I guess it could, but I'm not here to argue that point. The fact is, he gave the letter, and it should be honored on something that was done a long time ago. Plus, there's a house right in front of it that the exact same thing. Basically, you got an 80-acre tract with 3 26-acre tracts, and 2 of them have no frontage. But there's a house that's been there for 10 years that has no frontage either. So,
Actually, the property to the north, they came and received a variance from the Board of Zoning Appeals. So they are actually permanently buildable because they went through the right process and got the approval.
So all you're asking is for Dave to go through the right process?
Correct. That's all we're asking.
Dan
And you
Lynch.
don't have the authority to grant a variance?
No, sir. It's by
What
state
gave you
statute.
the authority to
so why
grant a
did he get the
variance?
building permit? Or what good did he get a building permit?
So,
Dan
Dan?
Lynch at 19751 219th Street. So I get these letters, and I've started getting them because that's what you have to do in the county to do it. I have no problem working within the rules that are here today. But what you're doing, if you allow these letters to be retracted, you're putting hardship on the constituents, the people of this county that are helping to pay your tax dollars. This shouldn't have this hardship on them.
no.
This letter should mean something. Bob, it should mean something, okay? It really should. Otherwise, and this is a very dangerous thing that was just said over here. It says these things expire. They should never expire. If you went to the expert to get it, under that ruling right there, I just got a letter from Jeff Joseph that said 24 acres, from you guys, the planning department, that said that my lot, 24 acres that I just bought, okay, is buildable, okay? You're telling me that that doesn't mean anything if
No,
you say
it's-
that expires.
It meets the guidelines at the time, the parameters at the time, and therefore, according to policy, it's grandfathered in.
Okay,
You wouldn't need that letter 5 years from now. The same policy would apply.
okay. What I'm saying is, somebody gave him a letter that said that this was a buildable tract, and we sold a lot. We as realtors, bankers banked it, title companies insured it, and realtors said, hey, we're good, because we went through the proper channels. You're saying that we're gonna take that stuff back. That you can't do that. I mean, otherwise, it's not, why are we going to you in the first place?
And it was wrong at the time.
Understood. Everybody makes mistakes.
We are
but
sure
it-
about that.
Well, John Zollner was
But
pretty.
your planner, that was the head of the department,
I understand.
issued the letter. So that's what I'm saying, and this has happened numerous times. It happened on the Bothwell property, a building permit was given, and all of a sudden, I'm selling the place, and people say, oh, if it burns down, it's not rebuildable. That's absolutely absurd. It's on 20 acres, it was given a building permit. Why in the world would this board have the authority to pull that permit? If that thing burns down, that thing should be rebuildable. Anything that is buildable today should always remain buildable unless somebody does something egregious to that property. And then I totally understand putting the people through the box of torment and saying, okay, now you gotta go through all these different variations in order to get this thing buildable. I'm okay with that, but when they didn't do a thing, that thing should always remain buildable. you guys owe it to the constituents of this county to create some type of resolution that stops this from happening. It just, it makes
I
it very
agree with
difficult
that.
for us.
I think we need to adopt some kind of resolution that stops all this stuff. And I don't agree with you when you say that this is a buildable lot for eternity. I just can't go for that. I mean, we have to have a timeline, Dan.
I understand. I want to ask one thing though, Bob. Your house burns down.
I have
Should you be
90
able to-
acres.
I understand. Doesn't matter if you had 1 or 80. Your
Yeah.
house burns down. Don't you think you should be able to rebuild that?
I think I should.
Without a shadow of a doubt.
Right.
Right? So you shouldn't have to go through a box of torment here to be able to get you
Right.
a buildable, a building permit. So that's what we're asking you to do today. We're asking
But
you to
my
honor.
house is not landlocked.
Correct. Bob, I understand.
Yeah.
I'm saying.
I know
and
what
you're
I know what you're getting at.
Yeah, that's all I'm saying. I need some help here. As a realtor that's selling things out in the county, all of us are running into the same thing.
Right.
Okay?
So,
We need things to be grandfathered in that were buildable, okay? And they should remain buildable. There shouldn't be something that takes it away.
Dan, they can't remain buildable for eternity. I mean, there's got to be a stopping place somewhere.
If somebody has a building permit already on that property and they built a house and that house burns down, that should remain buildable.
I think probably everybody agrees with that.
Okay.
If they
So
have building
then-
permit
then
and the house
why
is
in the
built,
world, when somebody burns down a house, would you put them through the torment
They did
of
not have
saying
a
they
building
have
permit when
a
they built their house.
non-conforming track, and that's the reason why you've got to run through a
Then
process?
that's a state requirement. We can't do anything about it. If the house is damaged more than 51%,
Mhm.
they have to go get a variance. That's state requirement. And the county has nothing to do with it.
Okay. That's in that. So I still think you should have some type of resolution that allows that to happen, where somebody
Yeah.
gets it.
It's a state requirement.
Well, could we have a resolution that would allow Mr. Joseph to grant a variance without coming to the board?
It's under state
State
statute.
statute.
I was gonna say, I don't think it's yeah.
Okay.
And I don't want to get off
can
task.
Can we issue building permits in lieu of them getting a variance? So that these people whose homes are destroyed, they're not waiting 6 months to get started again?
Commissioner, the problem is it'll come up again. I mean, the issue is not, it's only a temporary fix. The permanent fix is to go through the right process and get it, approved through the right board, so it's a permanent fix. They don't have to worry about it.
Well,
in
couldn't
that
they be
case-
going through that as they're rebuilding?
Yes.
And then if they don't comply, then you put something in the parcel file or something on that?
You can't make
I
it
think
tear it down.
there's two different discussions going on.
There
One
is,
one is
right.
about property that doesn't have anything on it yet.
Right.
And the other is about existing structures.
Yeah.
And I think that everybody, especially after the last person that came in that had the house burnt down, we all can see the struggle there. And I think that's maybe something we could work out where they can begin the process as long as they file the application and go through the variance procedure, that we could allow them to begin the process. That's something I want to work out and make sure legally we have the right to do it. But I would think that anybody in this room would agree to something along those lines, because not being able to rebuild a house is a problem.
Right.
That you've been living in, and like Mr. Lynch pointed out, no fault of yours, it's maybe the third or fourth owner since the thing was built. The other issue, though, the one of the
It's the
lots
building
that
permit, or the-
there's nothing
Correct.
on them right now.
Right.
If there was a building permit issued at one time, to me, it seems like it must have been compliant at that time. If there's never been a building permit issued, I think it's a little different scenario.
Other than we went to the experts to get the letter that we got. And Dave has
that's-
got the
And I
same
get it,
thing.
that's frustrating,
That-
because the letter shouldn't have been given, but it was.
Right.
And so then that is a policy decision that this board needs to make a decision
Well,
on.
and that goes back to, Mr. Zollner's not here to argue that point, and I wasn't involved in that, I just got involved in this recently, I wasn't involved in it years ago. But if Mr. Zollner gave a letter, and there's a paper trail with deeds from Carroll Beal for Tri-County Title showing when the deeds, the easement and to going back to the property were getting it, which made, and they were grandfathered in because they were dated way back, back in the 70s or 60s or something like that, that made it grandfathered in. he gave it based on the rules at that time that I think made it buildable, and whether it's right, wrong, or indifferent now has nothing to do with it. And Mr. Zoller was a good planner, or a pretty rigid planner, that you didn't get things through unless they were done correctly. So
That's all we're asking. We're
Right.
saying, hey,
I
guys,
mean, somebody went through a lot of trouble to get to that point.
Right.
And then now that doesn't mean anything because you guys say it doesn't meet today. And why should you have to go through a variance again to go through all that and spend somebody's money to do this and do that and waste everybody's time when it was given?
Well, I would say, and I think that you still need to do the variance. I think that the letter should grant some status behind your request for a variance, because the variance fixes it once and for all. And that's the problem.
Why wouldn't it? So that if they don't sell it 10 years down the road, then
But
you
once
do
you
it
get the
again.
variance, that's forever.
but it's a hardship put on somebody that
Right.
went through the right steps.
Well, but I think
to
that's what we're getting at, is the policy decision is if the letter exists, this board would support a variance. And then let the group go through the variance procedure. Ultimately, it's gonna come back up here anyways for approval of the variance.
Right.
Is that not right?
Where's the
That's all
Oh, no,
I'm
that goes right to the.
Why would you
That's
give a
right.
variance? This, it doesn't have any frontage. I mean, you can't change the facts.
Well, why would you let somebody build on a house that they can't get access to?
They got access,
They got it.
there's an easement going to it.
Part of the.
And that's what was given, sir. I mean, you gotta understand what we're talking
Sure,
about
all
here
right.
in the property. I mean, and it was given
But
legally.
you're
by
talking
their
about
board.
one property right now. We are not aware of all of the other letters that may be out there that may
Right.
not have that.
Well, this would
At
be
the
about
time,
as
they
bad
may
as
be
you
have
can
had
get.
they may have had a handshake agreement between the guy who lived next to him to allow them to have access to that piece of property, and now it's 4 different people have owned both pieces of
Well, I don't
property.
think that-
So
I-
the problem we have is saying carte blanche, these letters are great. Because
Well,
we don't know all the letters that are out there. I think that the letter should have merit. I think that we should take them into consideration as we're doing this process.
No.
But we
I don't.
can't just say that the
I'd like
letters
to
are
see
good.
one of these letters.
I think the letter should be, you should be able to get a building permit off the letter. And if you guys want to solve the problems.
Not
that
with me.
Or that this particular piece of parcel has, then you have them solve it. But I don't think it should be a cost to the person who bought it. That's what I'm saying, because they.
I would
went
agree
through
with
the
you
letter.
that there shouldn't be a
And
cost.
this
to
isn't the
that.
guy that did it. This is the second or third
I-
person down the
That's
road.
not- And that shouldn't be a cost to them.
I agree that maybe the policy would be that waiving any fees that are associated with the process, but I do think the variance is that ultimately, then it's resolved.
What does it do? It just solves something right now.
It gives them permission to break the law.
But
That's basically what it is.
That's what a variance
So at the
is.
end of the day, that's there. But the
And it's
point is,
recorded and it's done.
we need the letter to be able to say, hey, we can get a building permit on this, okay? So that letter needs to have merit, substance, it needs to be able to get that for his potential person, okay? And it's happened to me numerous times. This isn't the first time this board's heard this.
But you said the variance is a permission to break the law. Well, this person that got this law, he didn't break the law.
Right.
Your county employee wrote the letter, so he was an employee of the county, and he justified why he gave this building.
I
permit.
understand the
What-
letters.
Huh?
I understand the letters. I understand how they came into existence. That is not a question at all. I understand that. The question is how we resolve it, right? So the history behind them is the history behind them. The question is, how do we resolve it? And we need to see if there's even the ability for the board to grant that because of the process. We need to make sure that we're not in violation of any state laws. But it's a policy decision of the board if they even want to consider that. And that's the direction that we would have to have.
Okay, and Mr. Joseph, when your department puts letters out like that, do you have expiration dates or, I haven't seen one of yours.
What we call it, a status of parcel letters. No, that's a wrong
Right.
letter.
No, I know, this is Chris Dunn.
So the argument, and I get it, the argument is that these letters should have the same validity as your status of parcel.
That's right.
That's their argument, and a valid argument too, because the person at the time who got that letter did assume that it was
But the
binding.
problem is, it's not
But
gonna
how do we
go-
address
yeah,
it?
it's not gonna
That's
go
how
away.
we need to fix that.
At some point, they'll take the letter to the bank, and the bank looks at the parcel and it's landlocked. They're not gonna, honor the letter. So the permanent solution is to go through the right process, the legal process, and get it done. So it's a permanent solution.
And that's what I'm getting at with the board, though, is to find out if we can utilize these letters as a reason for.
He just brought something up.
But
So-
also the landlocked, if we need to make sure that, because some of these may now be landlocked that weren't at the time. And that's why I say we can't, we can't, your letter is, not your letter. We don't know about all the letters, and that's why I say it would be dangerous to carte blanche say every letter that was written is now valid.
Okay.
We need to review each one of them individually and make sure that because if we go in and give a building permit on a piece of ground and it's landlocked, we just allowed somebody to build a house that they can't legally get to.
And Jeff, in regards to the bank not taking your letter and meaning something, that's why we get letters from you. Okay.
No. What I'm saying is the letter that states that it's buildable, but the tract does not meet the regulations. At that time, when they wrote the letter, it was wrong.
Well, I understand, but what I'm telling you is that bank, if I took that letter there, that bank will do a loan on that letter because we went to the proper authority that said this was a buildable lot.
Yeah.
I know that they didn't do their homework. I understand that, Jeff. I got that. I totally do. This argument is about what departments like you in the past have done. And we are saying we have to have, those letters have to mean something. That's all we're saying.
That's what we do. When we receive somebody wants to, a letter from us, we do the research on the property and make sure it's buildable, it meets all the regulations. That's the only time we issue letters. If it doesn't meet the requirements, we say it's not entitled to a building permit, and you have the various options to go through.
Jeff, your office does that.
Correct.
We're not really putting you on the hot seat here. We're putting the previous departments on the hot
But
seat.
then it doesn't matter. I mean, that letter, if it says it's buildable and it's not buildable, at some point, you have to come back to the commission and do exactly the same thing that you're doing now.
But
What I'm
Jeff-
trying to
Jeff-
recommend is a way to
I understand.
to solve the
Now
problem.
that I've heard,
I want to go one more way.
Okay.
I want to say, I just want this, if we're going to go through and we're going to solve a letter that somebody issued, that problem, okay, that, because they didn't do their homework, whatever, then that shouldn't burden the client that has that letter. Those fees and everything, because they came out of this department, should be waived. And that variance that you're going to give this person should be a free variance.
It's not a free variance. I mean, you can use the letter to get the variance. And I'm sure the board will, look at those letters when they approve or deny the variance. But that's a factor that we'll consider.
Why do they have to go through this process? They went through the process
well,
once. Why do they have
so
to do it again?
now that we understand, I understand better what the discussion is and what you guys have going on here. I need to have an opportunity to look up and see how legally we can address exactly what you're asking about. Because I get the point. I understand that the letter that you have is the same as the letter that we issued today. Whether it was issued correctly or not, it's the same. It basically, our letter says this is a buildable lot as of today. That letter says the same thing, even though maybe it wasn't. You didn't know that when the letter was issued. So I need to see what legally we can do without getting sideways with any state law. And the board, then we can bring something back for the board for their consideration. So I don't want to.
And I'd like to be able to see if we could grant Mr. Joseph the authority to grant a variance without having to go through all the.
I don't think we can grant him that authority, but
I don't think so
I want to
either.
look
Think we
at.
can do it?
I want to look at what the state laws allow us to do.
I looked into that
and-
years ago.
And what we can do to, if there's a way to expedite it through the process.
Right.
And that I agree that the people shouldn't have to pay for that because they're trying to remedy something
Right.
that is a problem that a staff member created years ago.
And if someone buys that lot based on that letter, thinking it's a buildable lot, doggone, it is a buildable lot.
Well,
And why does the word variance even come up? It shouldn't even come into the conversation.
It is.
It's a buildable lot then, and it should be, and, what's eternity is a long time, but obviously, if something happens, that they redo something rechange the whole configuration of the surrounding properties, maybe it wouldn't be, but, you know, and I guess it'd be a case-by-case situation, but I don't think the word variance should even come into the
But
conversation.
that's the point exactly, that it should be a case-by-case, and we need to figure out how we address those that is not overly burdensome to the people who have these letters, and that's what.
And streamline it, so it can go through pretty fast.
As much as we possibly can, and stay within guidelines and within the legal limits of the law. We will,
Okay.
we will work on that, and we will try to get something back here. And I think there's probably, again, there's a couple of different scenarios. One is a lot that already has a house on it. The other one are these lots that have the letters but have no houses on it. And we need to look at both of those and see how we
We need
address
to really streamline the homes that are destroyed and
that.
can't build back.
Obviously, that's number one. That's the
Okay.
number one
And
priority.
there's not a lot of those letters out there, keep in mind.
Right,
I mean,
and
it's pretty
streamline the
rare.
letters.
Oh, and I don't know if we know how many
Right.
letters are out there.
That's exactly what we're
But no,
talking
but
about.
they're pretty rare. I mean, you know, we
Yeah.
run into them occasionally, but they're pretty rare. I mean, the bigger problem is where somebody buys a property and, you know, they had 10 acres and somehow they deeded off 5 acres to their cousin or somebody else unbeknownst, and then they create a non-conforming use property, and then these people go to get a building permit for a barn or a shed or add on to the house, and then they can't get it, and then they can't straighten up the situation because
They've already sold the property off.
Doesn't want to create it, so
Right.
you know,
I
so
think-
that's a totally different thing.
I think in the 90s, that's what was acceptable, deed off 10 acres,
Right.
or do 10 acres, then deed 5 back and get you a building permit.
I mean,
That
I'm in
happened
the
a
business,
lot
and
of
I don't
times.
understand the rules because they change
That's
often
what they
enough,
recommend
so the
doing.
consumers-
Is that right?
All right, Dean? When we had 10-acre tracts, you could build anything.
Allowed lot split to get 2 5s,
Mhm.
and then they took that 5 and lot split it to get 2 2.5-acre tracts, so they wound up with 4 parcels off the original 10-acre tract. That's why some of those rules and regulations came into place because of all the skirting that was going on back then.
Right. No, it was a different time.
What I might suggest is to allow us, I know Joe wants to talk up there, he loves talking, so I'm sorry, Joe, I'll give you your moment, but let me, before I forget, because I'm getting older, so. I think it'd be appropriate today if the board wanted to consider waiving any fees for anybody who currently has one of those letters that wants to start the variance process. So to get that going, and then we will work on this diligently to try to get something back here to get these addressed as soon as possible. But that way, if there's anybody out there waiting, they could then go ahead and start this variance process without
If there's any way, I'd like to be able, for Mr. Joseph to be able to grant these to streamline this.
We will look at whatever we can legally do on that.
Unless the laws change.
And the only, like I said, the only thing I would say is, today, it would be appropriate to go ahead and waive those fees if anybody wanted to start that process, and then we'll work on it, so.
Actually need to bring up one more thing. So in the case of like Jim Bothwell, when he's sitting out there and he bought a house on 20 acres, okay, and we go to sell the house, okay, and we just routinely send a letter, send a request up to Jeff Joseph's office, and we ask him, is this house buildable? And we get a letter back that says, no, it's not rebuildable. That totally stops our process of being able to sell that property. Because Mr. Bankerman, Mr. Appraiser, is gonna say this is no longer a buildable place. So, this is a guy that bought a house on 20 acres and nobody would ever think that's not buildable, but all of a sudden is. So we need to figure out how to address these issues quickly as well, so that they can get done.
I believe we had a special meeting for Mr.
We
Bothwell
did.
to get it done.
That was one, okay, but these happen more often.
I think
than-
that would probably fall under the same.
And that's
Just
what
as long as we address
It'd be
it.
the same things that.
I'd like to be able, for Mr. Joseph to be able, when you come in, he'll be able to grant it.
That's right. That's what I'd like to say. I'd like to say, Jeff, look at this.
Yeah,
This was on.
give him the authority to do that if we can.
Yeah.
That'd be my
Now, Joe, you
recommendation.
can talk.
Joe Herring, 315 North Fifth Street, Herring, Surveying. My concern is, there are a number of letters. Anytime a client calls me, whether it's these guys or whomever, we call planning and zoning and get a status letter. That's almost immediate, first words out of my mouth. Let's talk to planning and zoning, let's make sure we're doing what's right. The issue is, planning departments change. Opinions change, interpretation of the regulations change. It is obvious. Some of the people behind us, we've been up here a long time, coming before this board, longer than people have been sitting on this board or sitting in these chairs. This will change. The next person in here may not approve the way that this department wrote those letters, may not agree with them. So if the letters previously aren't worth anything, what's to say these letters coming out are worth anything? We need that assurance that what we're getting from the county and been written on county letterhead will go through. Property's not bought for 5 years. Like Dan said, banks lend money. They're bought for 30 years. They're investments. Putting a time limit on it is not reasonable in my mind. But we need assurance that the next planner, be it 5 years, 10 years, 15 years down the road, comes in, will honor what letters that his planners have signed. I have several letters that were signed by previous planners underneath them that may be in question. But, you know, we need that assurance. That's what we want. And we just want to make sure that.
And I think this board, I'm speaking for the board here, would like to see that happen and streamline everything we can. So Mark and Molly will be working on this, and we will stay on top of this and get something.
We'll work with planning and zoning, we'll work with the legal counsel, and we'll see.
Yeah, and like I said, if we can grant Jeff the authority to approve these in his office without going through all the hoops, that'd be great. And I don't think you need a billboard that says it's hard to get a building permit in Leavenworth County. I don't think you need to advertise that. I think everybody already knows.
Well, and you know, part of it is too, I mean, I just had a call from the Alexander Township that wanted to sell a little piece of ground that where a church was as a buildable lot, and I asked them if they've talked to planning, and I haven't checked it out yet to see if it is buildable, but it's like an acre, you know, on the right on, it's where a church was across from a cemetery. And you know, so if we get a letter from them stating it's buildable and we market that and somebody buys it, you don't want to have that person 10 years down the road have to come here and have to fight, and, well, you got to get a variance to prove that this is a buildable lot. I mean, that word variance shouldn't even, you know, when you get these letters, they shouldn't need, because they went through all the steps to get the letters. So, well, anyway, I appreciate
I think
your
staff's
time.
got everything they need to, all the information to go forward with coming up with a solution on this. Okay. Any other business to discuss? No, we've been through a lot today.
We do have one.
All right.
Is there something else you said?
One more.
Oh, okay.
These three members' terms are expiring, is that right?
Yes.
Have they all agreed to re-up?
Yes, we spoke with all three of them, and they would like to continue.
I would move that we reappoint Mr. Rosenthal, Matthews, and Earlist Moe to the Planning Commission.
Second.
Voting.
Aye.
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 Also, we have one planning commission member who resigned from the commission, Mr. Grossadier, and there is another person who is interested in it. I believe Commissioner Holland received a letter.
Yeah. Here's one for you and one for Clyde. I got this email in the mail last week asking to be appointed to the Leavenworth Planning. In fact, I had 2 applicants, and this one was the most recent, and I thought he was a good applicant. And
It's your district.
Yeah, we know Mr. Smith,
that's
and
who I proposed to have.
he was on the Board of Zoning Appeals previously. And
Okay. Well, like I said, it's
Is that your motion?
Yes.
Second.
voting.
Aye.
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 So it's Mr. Smith. Right?
We name the person.
The name of the
Oh.
person.
Oh. Was your motion to
approve.
To appoint
where is his name? What was the man's name?
Mr. Wolfgang Smith.
Oh, okay. Mr. Smith to the Planning Commission? Is that your motion?
Yeah.
All right. And we got a second, we voted. We're good.
Also, I have one more item.
All right.
There is a vacancy in the air quality forum with Mark,
Uh-huh.
and I would like to recommend Ms. Crystal Davis for that position.
I would too.
So we just need to
I
appoint.
move
Motion to
that we
approve.
appoint Ms. Davis to that board.
Second.
Voting?
Aye.
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 That's all right. Thank you.
Thank you for willing to serve on that. Okay. Motion to adjourn?
So moved.
Second, voting? Aye.
Aye.